The Florida Supreme Court is back in session. Please be seated.
Our next case is Worrell versus DeSantis, number 23-1246. Counsel.
Mr. Chief Justice, and may it please the Court, my name is Laura Ferguson, and I'm arguing on behalf of Petitioner Monique Worrell. Governor DeSantis' suspension of Ms. Worrell exceeded his authority under Article 4, Section 7A of the Constitution because the order does not allege any conduct by Ms. Worrell that, even if proven at a Senate trial, would constitute neglect of duty or incompetence. State attorneys are constitutional officers. They are elected to serve as the prosecutors in their circuit. They are invested with substantial discretion and independence and are subject to limited supervision even by the State Attorney General. They are accountable to the voters, and because they are elected and not appointed, they do not serve at the discretion of the governor. Under the Constitution, the governor's suspension power is limited to specified grounds, all of which entail egregious misconduct. For this reason, historically, most suspension orders have involved officials who have committed a crime or presented a grave threat to public safety. Removing a state attorney because of disagreements over the lawful exercise of prosecutorial discretion is unprecedented. While this court has treated blanket non-prosecution policies as an abuse of discretion, no blanket non-prosecution policies are alleged here. The governor is, of course, entitled to have different opinions as to how Ms. Worrell should exercise her discretion. He is entitled to endorse her political opponents. But short of conduct that meets the high bar for suspension, it is the voters, not the governor, to whom Ms. Worrell is accountable.
Counsel, can I ask you why, either textually or in a historically informed sense, if assuming it's kind of all of our precedents about how deferential this phase of review is, why is the concept of neglect of duty not broad enough in its broadest but still reasonable sense? Why isn't it broad enough to encompass the kind of things that are talked about in the suspension order here?
Well, first, we should look to the definition of neglect of duty that was in place during the most recent iteration of 7A, and historically has been the definition, and it entails the failure on the part of a public officer to do and perform some duty or duties laid on him as such by virtue of his office or which is required of him by law. And then more recently in Israel versus DeSantis, the court defined neglect of duty as neglecting an action required by one's position or occupation. So here I think what's critical is that there is no duty that Ms. Worrell is alleged to have neglected. Her duty as a prosecutor is to exercise her discretion within the bounds of the law and to look at each case on an individualized basis. So the executive order, for example, in the case of Andrew Warren, alleged that Mr. Warren had abused his discretion because he'd essentially abdicated his discretion. He wasn't deciding cases on an individualized basis. He had categories as to which he said there would be no prosecution. Mrs. Worrell doesn't have categories of non-prosecution. She's looking at each case on an individualized basis, and that is her duty.
That's not what's alleged, though. I mean, basically what's alleged, to kind of sum it up, is that she has policies that under-prosecute certain categories, and that she does not, it's not that she got a categorical rule that you'll never prosecute anything in that category, but there's a directive, an understanding that we really aren't going to focus on these cases. And I think that's a rough paraphrase of what's in the order, but that's kind of the drift of it. Wouldn't you agree?
The order infers and speculates about policies.
Well, it makes assertions. It makes assertions. I mean, it makes allegations, okay? And it doesn't have to prove it. I mean, we know that's what the trial in the Senate's for. But it makes those assertions, which may or not be warranted. That's not for us to figure out. I mean, you would admit that. We don't make factual determinations.
I agree you don't make factual determinations, but let's pick a policy that the order speculates Mrs. Worrell has, that she discourages line attorneys in her office from seeking certain sentencing enhancements. So even if that's true, it's not a neglect of duty for a prosecutor to do that because the statutes themselves.
Why would there not be an understanding of neglect of duty, or an understanding of duty, where that would be a neglect of it? That seems to me, then you're getting into really, that's kind of a political question, it seems like to me, the scope of how the duty is understood and how that's going to be defined. It seems to me to be, reasonable people can disagree about that, but the governor and the Senate have a constitutional responsibility to make determinations about what falls within the scope of neglect of duty. And under our precedents, we don't get into that unless it's something just like totally unrelated.
Well, this court has recognized its role in determining whether the suspension order is within the constitutional authority of the governor and to ensure that that order is not abusing that power. And as Justice Lubarga has noted, that the court's role is not pro forma, and this is especially important where you have an elected official. And yes, there are ranges of views about how best to secure the safety of a community, how best to use law enforcement resources, but generally we leave that for the voters to decide.
Counsel, can I just take you to a specific example? I'm going to page 7 of the order, the first full paragraph, which says that it alleges, this is an allegation, that assistant state attorneys are generally prevented or discouraged from direct filing cases whereby juveniles are charged as adults and are encouraged to effectively drop charges against juvenile defendants. That doesn't seem to me to be inferential. That doesn't seem to me to be an exercise of discretion. That seems to me to be a fairly concrete allegation. Now, it's not proven, but how do you address that specific allegation and tell us that that allegation, if proven true, would not constitute malfeasance, misfeasance, or neglect of duty?
Because the decision whether to direct file a juvenile is by statute within the discretion of the prosecutor.
You believe the statute would give her the ability to prevent. It doesn't just say discouraged. It says prevent. And then effectively drop charges against juvenile defendants.
So let me just make the sort of fundamental point that the direct file statute was amended in 2019 to end mandatory direct file. So now direct files are entirely within the discretion of the prosecutor's office. So therefore, there is no duty for a prosecutor to direct file individuals. It is within the state attorney's discretion.
You believe the state attorney could legally prevent the filing of charges in some form? Like it just, that strikes me as a pretty clear allegation of a policy, of not an individualized determination. If you prevent something, you're saying it's not going to happen.
If there was a categorical policy that this office will never direct file juveniles, then we're closer to having a neglect of duty. But even the executive order or the briefs acknowledge that Ms. Worrell's office does direct file juvenile. So there is no
But it seems like to me, you say if
policy.
it's not a categorical rule, then somehow it can't be a neglect of duty. That just seems to me to be kind of something that would lead to playing games. You say, we aren't going to have a policy, wink, wink. We just don't do it very often.
But that is within the state's attorney's discretion. So it's not as though in the federal system the prosecutors are appointed by, the head of the executive branch, and everyone has to be aligned on exactly how policies are carried out.
I understand that.
It's an
It is
independent
different.
office.
They are part of the executive branch, however, you would concede.
And also, they have a quasi-judicial function as well. They're created under the Article 5 that creates the judicial branch, and they are
But
officers of the court.
they are executive officers.
They are constitutional officers created under Article 5 of the Constitution, but they have a dual function, executive and quasi-judicial.
Well,
Are you suggesting that prosecutors exercise judicial power and it takes them outside of the executive branch somehow?
No, I'm not suggesting that, but they are officers of the court.
I have a question on, wouldn't you agree, though, that a difference in degree can eventually be a difference in kind, right? So you're focused on blanket policy. Let's say that a prosecutor had a policy that they were only going to prosecute 1% of juvenile felonies. In your view, could that constitute neglect of duty?
I think there is, in the absence of any statutory requirement that certain categories of juvenile offenses have to be prosecuted, as adults, which the legislature eliminated. They eliminated that mandatory requirement. Then it is within the state's attorney's discretion as how best to ensure the safety of the community.
That would be a fine policy for a prosecutor to have, that they were going to have a policy that only 1% of these juvenile offenses would be direct filed, and it would be some sort of lottery system, which one got picked.
Well, to be clear, that's highly hypothetical. That's not what's alleged
but
here. That's
we're
not
trying to
an
find
actual
out where the
policy.
lines are. Can a difference in degree become a difference in kind and constitute neglect? And if so, who decides?
I mean, absence the showing of some threat to the public that would justify executive interference in the democratic process, I think the system is intended to let the democratic process play out and let the voters decide. So the grounds for suspension are things like malfeasance or commitment of a felony or a complete incompetence. And it's situations where something has arisen after the election that necessitates intervention to protect the public, to protect the operation of the judicial system before the voters, are going to be voting again. Here, there's no emergency. I mean,
I'm sorry to interrupt you, but the order does allege that cumulatively all of these things do result in danger to the public. You're raising, obviously, these are very important issues about the proper balance between the governor's authority and local decision-making and all that. I mean, not to minimize any of that. That's very important. But it seems like our role, at least in our precedents, has been limited to having where it's kind of doubly deferential. It's deferential both at the level of defining the possible meanings of the terms in the Constitution in a way that I think essentially if there's any reasonable understanding of the words, because what we're here basically to protect against is the arbitrary exercise of power. So we have deference at the level of interpreting the words, and then we have deference at the level of what kind of factual allegations are reasonably related to that very capacious definition or understanding of possible meanings of the words. And so, it seems like unless we think that the only reasonable way to interpret the language is neglect of duty means literally just not doing, not showing up for work, or saying, we're going to identify these 8 types of crimes and just per se not prosecute them. It seems like we have to allow for the possibility that if you do your job, again, allegedly, we're not here to litigate the facts, but if you allegedly do your job so poorly and as a result of these decisions that you've made in terms of your policies and practices that they endanger the public, that then you move into the realm of having to argue to the Senate that, these other, either that that's not true or that the local control kind of predominates over that.
Here, the executive order does not identify conduct of Ms. Worrell. It doesn't identify policies in any concrete sense, unlike the executive orders at issue with State Attorney Aramis Ayala or Andrew Warren. In all the other executive orders that this court has looked at, it's been very clear exactly what the state official did that was problematic.
I'm just not
we
sure.
know from Israel. We know
I
from
don't know
Jackson.
how you can I got another one for you. Look at page 12. Whereas under Worrell's supervision, her subordinates have authorized or required assistant state attorneys in the Ninth Circuit to seek the withholding of adjudication in cases where such disposition is not permitted by Florida law. So just grabbing from that sentence, under her supervision, her subordinates have required ASAs to seek the withholding of adjudication where it's not permitted by law. That sounds like an allegation of illegal conduct, no?
Well, there's a couple layers to this. First, it's alleging that her subordinates have permitted.
No.
So that's like,
Yeah.
so
She's
it's
or
not about
required
her,
them, or required them.
her subordinates, not her, right? So, and there's been
Well, she's
a
the
lot of
elected official. I mean, that's the whole thesis of your argument, right?
Right,
Buck
but
stops
there's
with
no
her.
allegation that she's been derelict in her duty of supervision.
Well, I
her
would think that
subordinates.
if her subordinates were giving these orders and she was unaware of them, then she would be derelict of her duties, right?
And not necessarily, right? It's a large, busy office to neglect to suspend a state attorney for, an isolated instance by one of the line prosecutors would make any state attorney
I guess my
vulnerable
point
to
is,
suspension.
These are tribal issues, and this is an allegation. And
but
I don't know
I
how
just-
you can look at this and then say there's no allegation of conduct that would be violative of law.
What
It says-
duty is neglected here? Because the statute itself on withholds of adjudication, it says that if a state attorney is to, that a state attorney generally has some discretion to seek withholds. There are certain situations where, there's been a repeat offense where the judge is not permitted to issue withholds of adjudication. This order does not provide a single example where Ms. Worrell or someone in her office requested a withhold where it wasn't statutorily authorized. So again, it's unlike any other suspension order where we know exactly what the officer did in Hardy.
Counsel,
v.
before your
Coleman.
time runs out, and I'm sorry to cut you off, I want you to respond to the argument from the other side, specifically that we essentially lack jurisdiction because the issues raised by Ms. Worrell are non-justiciable political questions. Can you respond to that, please?
Your Honor, it is this court's role to interpret the Constitution. That role is vested in this branch, and we are just asking the court to interpret the Constitution and determine whether the governor has exceeded the scope of his authority under the Constitution. That is traditionally within the realm of the court. And even the Senate itself does not treat this court's role as interfering with its role. Its rules contemplate that there will be can be judicial review, and they will hold their proceedings in abeyance.
Well, I have a
there's
follow-up
been-
to that question. So the follow-up question is, can you tell me, are there any cases that you can cite where a Florida court has considered the political question doctrine that makes suspension non-justiciable?
Well, at the landmark
ever
leading,
decided
yeah,
at
in the
this level
landmark,
or- yeah,
at the
in
leading
Florida?
landmark case, Hardy v. Coleman, the court looked at the separation of powers issues and distinguished case Myers, where there was, an issue that was exclusively delegated to a particular branch, and said, well, suspension is different because already we have a blurring of which branches are involved. We have suspension with the executive, we have the removal or reinstatement with the Senate. So the separation of powers concerns are already not really sort of incorporated into the system. But in any event, there's no textually demonstrable commitment of the review of the suspension issue, to the executive. There's no language giving the executive sole power to determine the constitutionality of the executive's action, right? I mean, the impeachment cases on which the governor relies involved language saying that the Senate has sole power to try impeachment. So, of course, the court could not interfere with that. Or in McPherson versus Flynn, the Constitution says that the legislature is the sole judge of the legislature's qualifications. We don't have any language like that, and this court has always carefully walked the line between what its role would be in reviewing the suspension versus what the Senate's role is as weighing the evidence. And at this point, unless there's further questions, I'll reserve my time for rebuttal.
Just a
Yes.
question on the duty. Obviously, the Florida Constitution requires that constitutional officers, including prosecutors, take an oath to uphold the Florida Florida and the United States Constitution. There's a clear separation of powers provision in the Constitution. The veto power is the governor's in the Constitution. So when we're looking at being neglectful of duty, why can we not consider the context in which prosecutors operate when considering whether or not a blanket policy or a almost blanket policy constitutes neglect of duty?
Well, to be clear, there is no blanket policy or almost blanket policy, but I think inherent in the operation of the criminal justice system is the independence and the discretion of prosecutors. And if a governor were able to remove a prosecutor of a different political party simply because they disagree with their policies and categorize that as neglect of duty or incompetence, then that will have a substantial chilling effect on how state attorneys perform their roles or their willingness to serve.
Thanks. You can have 2 minutes for rebuttal.
Thank you.
Mr. Chief Justice, and may it please the court. The governor properly suspended Ms. Worrell from office because of practices or policies that she adopted as state attorney that contravened legislative policies and simultaneously resulted in the gross underperformance of her office relative to all other state attorneys in the state. We think that, of course, that policy judgment is not properly in front of the court. At most, your precedents say you'll ask whether there is some reasonable relation between the facts alleged and the neglect of duty and incompetence. As I think many of the questions this morning have hinted at, on these facts, that is somewhat of an easy question. And so I'd like to talk this morning, if I could, I'm happy to talk about any part of the case, but I'd like to start at least with our argument that the entirety of Ms. Worrell's petition presents a non-justiciable political question.
Before you get to that, can I ask you about the policies and practices issue?
Of course.
How much work is that doing in the order, in the sense that, I guess I'm curious if you thought it was necessary to allege that as opposed to just putting in a bunch of stats about how in the governor's view, the state attorney is just not protecting the public, at a level that reaches duty. And are you planning on actually proving specific policies? And I don't know what exactly a practice is, but, what is the role of that allegation in the order?
I think that they all work together, but they also work independently. And so if we had no allegations at all about practices or policies, and it just turned out that Ms. Worrell was not very effective at prosecuting crime, and the data, I think does prove that. I'm happy to talk about that in sort of granular detail. But if we had nothing else than the data, I would think that would be enough. Now, the practices and policies make that even stronger, and some of the questions have gotten at, exactly the ways in which these policies are improper and frustrate things like the legislature's zero tolerance policy. It wants there to be these minimum mandatory sentences for individuals who commit drug trafficking and firearm offenses. And Ms. Worrell's answer on some of those points, if you look at page 41 of the petition, with respect to the firearm minimum mandatories, she says, well, there's nothing in those statutes that prevents me from sort of evading the min-mans by downcharging. And so if I had a robbery with a firearm case that I knew that I could prove, the suggestion is that she would downcharge that and plead out just to a robbery without the firearm to evade the min-man. And I do not think that could possibly be what the legislature had in mind when it said zero tolerance and you must impose these certain minimums. But again, if there was nothing else and we just had the data, and what some of that data shows, take the prison admissions for 2022 to 23. So if this is 100% of the prison admissions statewide, she was at 38% of those. I mean, that really is an abysmal record. And if we had nothing else, if there was nothing specific she was doing, she just was not effective at prosecuting crime, we think that would be enough.
Let me ask this. We recently had a case before us where this happened. Let's say there's a inner city type of crime where there's a drive-by shooting and a young girl gets shot. Only one witness saw it. And state filed charges based on that one witness who saw who shot him. Sure enough, as can be expected in many of those cases, later on in the case, depositions come around, the witness suddenly couldn't remember. Now the state is left with nothing. He had the case charged with a firearm, which obviously aggravated the penalty. In that case, the state is faced now with either offer something in way of a plea, get something from this guy, a few years in prison, whatever, or just take it to trial and surely result in a not guilty or a directed verdict, a judgment of acquittal by the judge. So, Arnie, what we're doing here today, placing a chilling effect on prosecutors for making the decision, let me take something, let me eat the gun, meaning take that out of the sentencing process, and let's offer this guy 2 or 3 years in prison, or at least get that out of it, or I better go ahead and just take it to trial and just fly the airplane against a mountain, because if I don't do that, the governor's going to fire me. Isn't that what we're doing in major metropolitan area where we get many of those cases?
So I don't think so, Justice Labarga, and I recall that case very well. I think, what you're describing would be a valid exercise of prosecutorial discretion.
Well, who decides that? I mean, do prosecutors have to call the governor and say, or the governor's general counsel, whoever, and say, look, this is what I need to do here. Is that okay with you, Governor? Who decides that?
And we're, of course, not saying that. I would say a couple things. Number one, the Hardy versus Allen case from 1937, I do think stands for the proposition. That was the gambling case. I do think stands for the proposition that the label prosecutorial discretion doesn't insulate a state attorney from suspension for neglect of duty. That was a case in which it was not a blanket policy case. There had been gambling prosecutions brought by that county solicitor, and the governor decided that there had not been enough, and even identified some specific instances that he thought should have been charged. And this court said, applying the applicable quo warranto standard, that was properly a case that could go to the Senate to decide. And I think that's the real answer, and that's part of why we believe that this is non-justiciable, because the check and balance in that circumstance is a political one. Not only the fact that the people elect the governor and he is accountable to them, but also because the Constitution, the people themselves, set up the Senate as effectively performing the judicial review of a suspension order.
So, counsel, what would this court's role be? How do you square that? Let's say we agree with you that this does present a non-justiciable political question. What is the court's role in issuing these writs of quo warranto?
Justice Francis, we would draw the line much in the same way that you proposed to do so in your concurring opinion in the Warren case, which is to say that you could identify some very specific, straight up or down, yes or no type of questions where you have a judicially manageable standard, and those the courts could address. And so, for instance, if the governor attempted to remove, and this of course would never happen, if the governor attempted to remove an official who was subject to impeachment rather than suspension, I think you have a clear judicially manageable standard to say we can step in and adjudicate that case. I also think that along the lines of the concurrence, you might say something like, is there a written order that states grounds and that is filed with the state custodian of record? That would be justiciable because of the presence of judicially manageable standards. The problem is, and this is the difference as we understand it between our view of the political question doctrine and the reasonable relation test that you apply now, is because there is at least some argument that a claimant could make that the stated grounds do not have that nexus. And as soon as you get into doing that sort of inquiry, you do have to think to yourself, well, what do I believe that a neglect of duty for an executive branch official would look like in this context? And even if you are deferential about that, you are still exercising a political judgment call about what conceivably that neglect of duty could be.
Don't you think we could look at what a reasonable view of that would be? That's not necessarily judges do that all the time. People do that all the time. We look at what a reasonable view would that be, and we're highly deferential. Why would that preclude review altogether, because we have to consider reasonableness as part of the analysis?
Well, I think, Justice Grosshands, if the standard really is that deferential, then you probably get to the same place in a lot of these cases anyways, and the fact of the matter is you have not been quashing these suspension orders under the reasonable relation test. But part of the problem is that it always invites litigation. So even though you have laid out this very deferential test, and it's been the rule for decades, we still end up with pages and pages of briefing on things like, what do the facts show? What does the evidence show?
Well, how would you reconcile, your political question doctrine and this idea that this whole area is non-justiciable with the Section 21, Article 1, access to courts, that courts shall be open to every person for redress of any injury? I mean, that's just as much a provision of the Constitution as what you're citing to say, no, actually, in this case, the courthouse is completely closed. No one can raise this question here.
Well, and to be clear, I do think that there would be some judicial review. It's just you would perform that review where you thought that there was a judicially manageable standard. The second thing I would say about that is that the political question doctrine just sort of bakes in that idea, and I suppose the same thing could have been said in the Citizens for Strong Schools case, where the question was, does adequacy or high quality have some kind of judicially manageable content? And the court said no, and thus the courts had to be closed in at least that limited respect. But that does seem to be the way that the U.S. Supreme Court has analyzed these questions. It said in cases like Baker versus Carr, there are no political cases, there are just political questions. And so you really do look to see what are the claims, and is this the type of claim that would be appropriate for judicial resolution?
But I think these are terms that are, if you look at the overall context, the voters chose not to say, the governor can remove state attorneys for cause, or if the governor thinks, he or she, the governor thinks the state attorney is doing a bad job. They chose kind of legally recognized terms with a long history. The person is elected, they do have certain interests / rights and, their job, et cetera, et cetera. And so, unless, if we think that the Senate, if what they're doing is kind of a substitute for a, trial-like thing, they're applying real standards. I mean, I don't think that there's anything that's inherently kind of unmanageable about the terms. Obviously, you'd have to ask yourself, and I think the court has sort of thoughtfully over time developed this very deferential understanding of what that is. But, I don't think that it's something where it's just, when you see it level subjectivity. Otherwise, the whole thing doesn't make any sense.
Well, just to give you an example about the kinds of interminable line drawing that you'd be required to get into if you were to do this type of review, I think everyone would agree, if you just, going back to the prison admissions, if the allegation was that a state attorney only obtained 5% of the prison admissions that everybody else throughout the state obtained, we would say that's a really easy case. Of course, that person was neglecting their duty. This case is 38%. That also seems like an easy case. But if you get to 65 or 70 or 75%, I think you could see how it might be a little bit more of a difficult question to say, yeah, we think that side of the line is neglect of duty, that side is not. And so, I do think that's where the use of political judgment comes in, because
why isn't it? Why isn't it more less a question of judicially manageable standards, and more a question of what the proper scope of Quaranto review is? And so I don't see it as us trying to land on where or not there's a judicially manageable standard so much as we have the constitutional authority to hear petitions of writ Quaranto. What is the proper scope, and whether or not our case law has stayed within that scope. So if that's the framework, then for something like neglect of duty, let's say there's an executive order that somebody, a constitutional officer says on Facebook, like, oh, I was super neglectful, I burnt the casserole, that's appended to the executive order. Would Quaranto be broad enough for a court to look at that and say, the governor does not have the authority to suspend for negligent baking of casseroles, for example?
So, I think if suspension cases under Article 4, Section 7 were the entire universe of quo warranto cases, that might be more palatable. But the fact of the matter is quo warranto has all sorts of applications. Setting aside the governor's suspension power, that power is just one particular application of the writ. And so I think a big part of our argument here is that there are clear textual commitments to the Senate, and this court has said this, that like in Israel and Coleman, that the Senate itself is the court that the people set up to decide these questions. And so I think to some extent that displaces the more generalized quo warranto authority that you would have to get into in detail and judge the sort of sufficiency of the factual assertions.
Can we talk about precedent, though? Because it seems like Allen, this is a difficult issue, I think, that they wrestled with. They wrestled with the textual allocations of who's doing what. They wrestled with the idea of the individual's, right. Judicial power is about enforcing individual rights. This removal thing, it's not even a trial referred to textually the way impeachment is. They came up with what I think is a very thoughtful resolution of it. You had opinions that ran the gamut. Buford's opinion is essentially kind of anticipated your argument 90 years ago. They didn't use the term political question, but he makes all the same arguments. He says, I'm not even going to participate because we don't have jurisdiction, and here's why. Fast forward 30-something years later, the voters adopt a new constitution. They don't say anything to kind of fix this by adding words like soul or telling the courts to butt out of it. Why would we not accept that resolution that's been part of our constitutional history now for 90-something years, other than maybe just this kind of, you're wasting your, everybody's time with these things because it's so deferential that the court ends up saying that it's all within the zone of reasonableness. I mean, I don't understand why we would make some pronouncement about justiciability and not having jurisdiction, et cetera, when it's such a well-established thing and where it's, hardly obvious on the merits.
Well, it's certainly not obvious to the quo warranto petitioners themselves because they come to you time and time again and they make these arguments. But look, I mean, if where you end up getting to is effectively the same place because you clarify that the reasonable relation test truly is this deferential, I think that solves many of the concerns. But, all I'll say is that the logic that the court espoused in adopting that test does not quite match up with the end product because you still end up with a test that has the judiciary sort of making, in some sense, these kinds of difficult policy decisions. And I think as a matter of doctrine, the correct answer is that this is non-justiciable.
But why is it, it's not to say, I mean, it's kind of bread and butter judicial job, it's part of the job to interpret words and to identify kind of reasonable, not necessarily, I think this is clearly an area where the court has not said, we're looking for the best meaning of the text. We're looking for, they're trying to establish what could a reasonable person think neglect of duty is or misfeasance is or whatever. And that's core, I mean, that's our bread and butter. That's what we do every day. So that it's not like we're, being asked to say what's the optimal amount of money to spend on textbooks in schools or something. So I just don't understand. I mean, the notion that we're somehow at sea and this is so subjective, et cetera, we've never claimed the authority to say definitively this is what the word means, and all we're looking for is evidence that might support it. We've always allowed a zone of reasonableness, even into the definition of the phrases in the Constitution.
Well, I do think that and you raise fair points. I think that maybe some clarification to the public at large about what the standard looks like might be helpful here, just because we end up making these same sort of fact-bound, arguing about the evidence in all of these cases, it seems like, and so maybe the message hasn't quite gotten across. But, I guess the only thing I would say with respect to the precedents is that the modern political question doctrine really didn't come along its current iteration until the 60s with Baker versus Carr. And as to whether there's been any change to the text of the Florida Constitution from the 1885 version to the modern Constitution, Article 4, Section 7, the one thing I'd point out is that there has been a slight textual change, which is that before the Senate didn't have the power to reinstate. It sort of de facto did if it didn't act or if it decided not to remove, but it now has the power to reinstate. I do think it's telling that there are only two governmental entities listed in Article 4, Section 7 with the power to reinstate, which is the governor himself and the Senate. And that reinstatement power really does look quite a lot like a form of judicial.
Let me ask you this. Assuming that the court adopts your non-justiciable political question doctrine in this case and in other cases like it, does that leave the Florida judiciary with any role at all in these cases?
Yes. And so, for instance, if the governor were to attempt to suspend the Speaker of the House, I think you would step in and you would say that is an ultra-virus action which does not even arguably fall within the governor's power, and quo warranto would be appropriate there. But you would look for those kinds of very concrete judicially manageable standards.
Kind of like what we have in citizens initiatives, where we just look at whether or not the summary has 75 words instead of 78 and that kind of thing.
Right.
Something that.
Right.
I think there's a lot of people who'd say we do a lot more than that in that area. But.
I would
With respect to that one
I would
question
know.
about counting words, yes.
So in no scenario would this be a dismissal with prejudice or dismissal for lack of jurisdiction then? Because it is presented to us as a petition for pro Ronto. We conceivably have at least the ability to review whether or not the governor had the authority to suspend, whether or not the prosecutor was a constitutional officer, that sort of thing.
Well, I think what Baker is saying is that you look at the nature of the claim. So you wouldn't say the whole categories of cases is non-justiciable. You would look to see what type of claim did you bring. And so if the claim being brought lacked judicially manageable standards, you would say, we dismiss for lack of jurisdiction. If the claim that had been brought was some, concrete judicially manageable issue, like was there a written suspension order at all, then I think you would say we have jurisdiction and we'll adjudicate that.
Did you say Baker? Like Baker versus Carr?
Right.
So we're going to, instead of just following 90 years of Florida precedent, we're going to try to figure out how Baker versus Carr should apply to this?
No. I was simply saying that that's how the U.S. Supreme Court, at least, has understood the political question doctrine. You sort of go issue by issue, not just like category of cases by category of case. So that's all that I meant to suggest. And of course, the court has, in many ways, modeled its modern political question jurisprudence on what the U.S. Supreme Court has done. But thank you very much for your time. We think that the case should be dismissed or denied.
Thank you.
It's remarkable that the governor's lead argument is that this court cannot review whether his order is constitutional. And this is a governor who has used the suspension order with great frequency in an unprecedented way and targeted at those of a different political party. So I do think this is a case, Chief Justice Muniz, where there should be some scrutiny of whether there's an abuse of the power. And in terms of whether the court has previously recognized that prosecutorial discretion is fair game and Hardy versus Allen is a non-prosecution case. It's not a prosecutorial discretion case. The reason that the court approved the suspension order was because it interpreted the official as knowingly permitting gambling and preferring no charges therefore. And similarly, the executive order understood Hardy versus Allen as being based on, quote, an alleged unwillingness to prosecute gambling offenses. That's the order at issue. Ms. Worrell does not decline to prosecute any category of offenses. It's even the admissions data shows people have been prosecuted across a range of offenses in her jurisdiction. In terms of whether the facts alleged are reasonably related to neglect of duty or incompetence, reasonably related is not a standardless test, and what this order predominantly relies on is prison admission data, which is not reasonably related to whether a prosecutor has neglected their duty, because there's a host.
Let me ask, I think the gist of what the court is saying, and the point here is that this executive order is in many ways like an indictment or an information filed in criminal court, where all the state attorney is required to do is minimal allegations that a crime has been committed. And then it's up to a jury to decide whether the person's guilty or not after the evidence has been presented. Here, the argument is that this is the same thing. They make the allegations here in the order, and then the Senate will hear the evidence in the case, and the Senate will decide, the jury will decide whether Ms. Worrell is guilty or not of these things. And all those arguments you're making here today will be presented to the Senate, and the Senate will hear it and make a decision. How is that improper?
So the executive order here, unlike an indictment, doesn't identify instances of misconduct of Ms. Worrell. It just speculates that because she ran on a particular platform, she must have certain policies, which they can't identify a single policy The order talks about how her office discourages, which doesn't sound like a policy. It talks about practices, but can't identify a single example. Practices implies multiple examples. They can't list a single instance where there has been an abuse of discretion. So an indictment tells the defendant, here's specifically what you did, right? And maybe not in great detail, doesn't have to provide evidence, but this is just speculating. Oh, we see you, state attorney, from a highly densely, populated urban area. Your numbers don't look so good as compared to other circuits where these numbers are about prison admissions, which state attorney, cannot control. There's a host of factors, as you noted, witness availability. Plea bargains are an accepted part of the workings of the criminal justice system. State attorneys are encouraged to plea bargain. There's a host of reasons. The judges control sentencing. Evidence may not be available. There may have been police misconduct. There's a host of reasons that could affect prison admission data. So it is unreasonable to rely on prison admission data to conclude that a state attorney has neglected their duty.
Sorry, you can have 30 seconds to conclude if you'd like.
Just to summarize, the executive order does not identify any concrete conduct, any specific policy, any instances of abuse of discretion by Ms. Worrell that could be considered neglect of duty or incompetence. Instead, clearly there's policy differences, but those are to be resolved in the democratic process through elections. There needs to be some really more egregious, systemic, pervasive problem where there's a demonstrated abuse of discretion to warrant the executive stepping in and removing an elected official. So we ask that you declare the executive order invalid and restore Ms. Worrell to her elected office. Thank you.
Thank you.